I'll direct this to you, Ms Noble. The Secretary in his opening statement has spoken a little bit about the threat environment. I wonder if you could flesh that out a little bit from ASD's perspective and give us a picture, to the extent you can in a public hearing, of how serious the threats are that we face.
Certainly. The threat environment is definitely deteriorating, and to give you a sort of evidence-based point of that, there's been a 60% increase in ransomware attacks against Australian entities between this year and last year. One of my US colleagues recently said that she thought there was a significant risk of catastrophic cyber attack in the United States. My contention is actually, if you're JBS or you're Nine or you're Toll Group, all very brave companies who have spoken publicly about what's occurred on their networks, those catastrophes have already happened, and the impact of those on their own businesses, but also the services that they provide to Australians and the employment of their own workers, I would put to you as already in the catastrophic sort of realm of impact. We see both state-based actors and also criminals operating against Australian entities. They're motivated by a range of different imperatives, anything really from espionage to generating influence or actual interference, to preparing to or actually disrupting, degrading or denying services, not to mention just the pure criminal motivation of stealing money. And like a lot of criminals, they try to steal it from the most vulnerable using tools that are available on the internet, that are syndicated, that are provided to you as a service on the dark web, and frankly pretty easily accessible should you have the motivation to access them. The vast majority of the attacks that ASD are aware of over the last year are actually focused on critical infrastructure sectors or systems of national significance. For example, we've seen significant targeting of the health sector. It's that combination of fragility, a perception that they're vulnerable, particularly as they work endlessly and tirelessly to help us in a pandemic, and therefore as a victim might be more willing to let their defences down, be prioritising other things, and then pay a ransom to try and quickly recover. And our data certainly underscores that. Not to mention, I guess, in terms of the broader economic cost, AusCyber, by way of example, have estimated that a significant cyber attack against Australia could cost $30 billion and 160,000 or more jobs. So I guess that's a very quick sort of thumbnail sketch of what we see occurring in our environment.
And to be clear, because most of those examples that you've cited, to my knowledge, whether it's Toll or Nine or JBS, and there's also the recent experience in the US with the pipeline, they all appear to be criminal in nature from what's available on the public record. But this bill is equally aimed at preventing or safeguarding against state-based actors and their motivations in this space, isn't it?
That's absolutely right. And in June last year, the Prime Minister made a public announcement about one such significant campaign, I think probably the most significant campaign against Australian entities by a state-based actor. So they're out there as well, and it's not only one country. There are a number of countries who have an interest in Australia for espionage, influence and interference purposes.
In evidence before the committee today from the Victorian Information Commissioner and the Law Council, they both characterised the cooperation that they observe or that they personally has received from the business community when threats of this nature arise as highly cooperative, very receptive. The Victorian Information Commissioner, I think, went as far to say that she was not aware of any examples of where they were non-receptive or non-cooperative.
And I should add, and probably too late, because by that stage the house is on fire, it's burning down.
Yeah.
So in desperate circumstances, people will collaborate.
Yeah.
Although even so, I think Director General, sometimes even there you find an obstacle placed in your way.
Well, that's exactly what I want to come to, Mr. Pizzullo. Has that been ASD's experience? Are businesses always cooperative as they should be when this happens? Because what some of the submitters are trying to understand is why it is necessary to have these quite, some would say, extreme powers to force people to cooperate. If it is the case that they're always cooperating, why would it be necessary to force them to do so? Is there any examples that you can talk about where that hasn't been the case?
Absolutely, and that is not our lived experience. So whilst we do have some wonderful examples of incredible cooperation, and you might recall a couple of years ago in 2019, significant impact of ransomware against the Victorian health system. So by way of a good example, in that example, we have a close relationship with the Victorian government, and they also had a private incident response provider. So this is a terrific example of state, federal government and the private sector working together. Good looks like they contact us, we are able to work with them, they provide us technical information off their network, like logs, images of disks. That happens on day one. Within that same 24 hours, we sent incident responders down on the ground, working side by side with the Victorian government, the private entity impacted, their private service provider, and our staff from the Australian Cyber Security Centre. We were able to quickly fully map the network. We were able to identify the nature of the criminality, and why does that matter? And I guess the difference, and I'll sort of come back to what bad looks like in a minute, but what's our value add there is that our people in ASD are in hand-to-hand combat with criminals and state-based actors every single day. We have the benefit of top-secret intelligence provided to us from around the world, not just our own intelligence that we can gather. 75 years of investment in technical capability to analyse and unpack it, with an incredible posture and ability to understand through our cyber defence capabilities what's happening on Australia's internet, with great partners in our telco sector, for example, constantly exchanging threat information with us. So we can, our value add in that scenario is our people are much better and quicker at identifying what actors look like, their tradecraft, they repeat their patterns, they leave fingerprints, and then when we can recognise it and have seen it before, can often act very quickly to remove that malware off the network and get the network back up. That whole Victorian incident, we were back up and running together in 4 days. What we left them with was also tools, training and capability to identify, to protect themselves from a similar attack, but more quickly identify it happening again.
So that's the good.
That's good. That's what good looks like.
What I'm interested in is the
bad
alternative.
Looks like, and this is a real example, but I'm not going to name names, it's really important. We find out something's happened because there are media reports. Then we try to reach out to the company to clarify if the media reports are true, and they don't want to talk to us. So then we keep pushing. Sometimes we have to use our own very senior level contacts, sometimes through people in this building who might know members of boards or chairs of boards, to try and establish trust and build a willingness to cooperate. We have at times then spent nearly a week negotiating with lawyers about us even being able to obtain just that basic information that I described in the first scenario of, can we please have some data from your network? We might be able to help tell you quickly who it is and what they're doing and what they might do next. So in this case that I'm referring to, 5 days later, we're still getting a very sort of sluggish engagement of trying to get them to help provide data to us and deploy some of our tools so we can work out what's happening on their networks. That goes for 13 days. This incident had a national impact on our country. On day 14, we're able to only provide them with generic protection advice and their network is still down. 3 months later, they get reinfected and we start again. That is the sort of scenario where this legislation actually just gives us the authority through Home Affairs more leverage to expect these critical infrastructure providers to actually have better cyber security standards in the first place. The best part of this legislation, from my point of view, is if they look after themselves, it doesn't become work for my people. And if their defences are much higher, they're keeping the low-level crims out, and then we might be able to focus on the much more sophisticated, highly organised criminal syndicates or state actors, where we'd like to focus our energy on that.
So that's frankly extraordinary evidence that I presume this was not a small business. I appreciate you can't name them in this context, but I assume they fell into the critical infrastructure space. They were a systemically important business.
I think it's fair to say, we can say it was a nationally known case involving a nationally known company that Ms Noble and I are declining to name at this point.
Yeah.
Can I add a policy perspective?
Please.
Because we see the Director General's travails in this area, and the reason why we've gone for these measures, which we contend are not oppressive, they are proportionate. And I was frankly astonished when and you do hear this evidence, and you hear it from both those who are technically in the game to ensure that their products and services are sold and resold, and no, you don't need the government at all, and then there are others who've got a different perspective. I don't draw any adverse inferences from their motivations. Safe to say this: it's not the lived experience of the agencies, and that's just been evidenced to this committee. But even if it was, what that evidence suggests to this committee is, there's tremendous cooperation at the scene of the plane crash. Every time one of our planes go down, of course we collaborate with the investigators and we work out where all the bodies were and the wreckage of the parts, and we help with the safety investigation. We would not tolerate it in relation to aviation safety. In fact, we learn lessons from crashes, but we also regulate the movement of aircraft through our skies. Now, given the development of the internet, it's been organic, it's been driven by a somewhat unusual combination of libertarian impulses on the one hand and profit-driven motivations on the other hand, and there are lots of good reasons to drive down costs and to connect your business, to connect your plant machinery to the internet, to monitor it, to increase its performance. Every time you connect, you are flying unsafely through airspace. We would not tolerate our airspace being ungoverned and unregulated by the state. And yes, of course, then there are still plane crashes because you can never reduce risk to zero. So the evidence that was put to this committee, I would contend, respectfully, is really saying to this committee, don't worry about it, just attend the scene of the plane crash because there's always terrific cooperation. Well, as you've just heard from Ms Noble, even at the plane crash scene, that's not the case. But I would contend that this Parliament's got a different duty upon it, which is to think about the regulation of cyberspace in the way that you would think about the regulation of other commons.
Help me understand why a business would decline the assistance of ASD, why they would be reluctant to cooperate. I find that
Ms Noble, do you want
very difficult to understand.
Would you like to chance your arm at that?
I'll give you my theories. Well, and also our lived experience that once we do get to the point of cooperation, then we can have more open conversations about this. It can be a range of factors. One, no, we're fine. We've got this. We've got an incident, a private incident responder, and we think we're going to be fine. Can be driven by a little bit of ICT professional hubris. Like, I want to believe that I've got the technical skills and I don't need help. That's okay. We understand that people feel that way. That's usually before they've actually fully appreciated what they're dealing with. So some of these criminals, they know what they're doing. They do this all day, every day. When you're experiencing that for the first time, you know, it can be confronting. You don't really have the experience to understand just what they're capable of, let alone state-based actors. So I guess there's an element of that. The second one is the motivation that I think often brings the lawyers into the room and the conversation, is that they haven't had the plans for this occurring. They don't know how they're going to manage their public communications about that. They're concerned about their commercial interests, the people that they provide services to them, their brand damage. So there's
possibly legal liability, directors' duties, those sorts of things.
Almost certainly the loss of future business, the loss of your business, and so they are trying to contend with all of that, whilst they're also trying to contend with the incident and getting the network back up, which is of course their.
But how does holding ASD at bay to help fix the problem protect them from a class action or a prosecution for failing their obligations? I mean, it doesn't seem to make intuitive sense. I think you're going to adopt them in, or I mean.
Well, it can. It's a third party. Someone else knows. I know you say you're from the federal government and you're not going to talk about what you know publicly, but how can I really trust you? I want you to sign an MOU, a non-disclosure agreement, before I even tell you, where my network is. So it can be sort of about trust. But one of the points that this bill goes to is also the fear of if you're in there with us and you give us instructions, who's going to be liable for that?
Yes.
And what will be the consequences? And I think this bill will assist in taking away some of those points of concern that create the reticence to engage with us.
Yeah, and so let's talk about that, because even if the Parliament grants you these powers to force compliance, I think this hesitation on part of the corporate sector needs to be resolved anyway, because we want them to be compliant voluntarily and cooperatively. Yes. So what more can be done in the legislation to remove these anxieties that they have? Some submitters have said that the protection from liability offered in this bill is not sufficient, doesn't extend far enough, and they still could be. For example, if they're directed to do something by ASD and it doesn't work out well, that they could be liable for those actions. What can you say to reassure them?
I would emphasise in evidence to this committee that we're conscious of that as an issue, and I would urge the committee not to see this as a standalone measure. As I said in my opening remarks, as a suite of measures, one that I just very briefly touched on, and this is an opportunity, your question gives rise to an opportunity for me to flesh this out. There's a complementary piece of work that was announced last year in the cybersecurity strategy that goes precisely to the question of corporations law, directors' duties, better practice regulation in this field. It goes back to the air safety and airworthiness, a metaphor that I just used, not a metaphor, it's actually an example. In fairness to the boards and in fairness to the executive management teams that are grappling with this, things like insurance products, the actuarial costing and pricing of the risk, the depth of the reinsurance pool, the case law is not particularly well formed. We really are in the early days of flight. It's just that the adversaries learnt how to fly, and they've got better planes at the moment than most firms. So over time, my thesis to you, Mr Chairman, would be that there'll be some corrective actions that are market forming, because frankly, deeper and better capability will start to be deployed because they'll have to respond to these obligations. Yes. Insurance products will start to be framed. Prudential standards, there's already a prudential standard under APRA's jurisdiction that's applicable. APRA are looking to work with us as part of this better regulatory framework, which is complementary to the obligation. So just to give the Parliament context, and this might be one of those other matters dealt with by way of supplementary advice, we're not in a position to preempt where the Treasurer and the Home Affairs Minister have got a joint lead in terms of the comeback on the regulatory environment.
Yes.
We might seek their guidance as to how much we can put forward. Addressing some of those questions of liabilities, we would contend are best not dealt with through this legislation, but through complementary mechanisms that might go, for instance, sector by sector. They might be dealt with through corporations law, for instance, if it goes to duties. There might be some challenges and issues that the Treasury needs to work through in terms of cyber insurance and reinsurance. We would contend that this Parliament's faced with a multidimensional challenge that's going to require a series of tools that are interdependent. If we wait for the full suite of tools to be laid out, we could be waiting a year, 2 years, 3 years. This problem is growing exponentially. So we would contend that those are live issues, they're important. We would contend that the obligations that are laid out in the bill are both proportionate and the immunities are reasonable for the direct actions that Ms Noble referred to. And Mr Hansford might want to flesh out the protections and immunities of, in effect, the firefighter running into the building to deal with the fire, which is the point at which ASD is really involved in the most egregious cases. But I do want to draw the committee's attention to parallel and consequential work going on in the regulatory space that is coming back to the government at the end of the year.
Thank you.
Do you want to add anything on the immunities question?
Maybe just 2 points. The first point, and to pick up on some of the Director General's evidence, a company has to be unwilling or unable for the action directions and for some of the measures in the ministerial authorisation. So in the circumstance where some of the legal issues arise, such as a contractual issue that a firm's worried about, you could effectively issue a friendly notice where a company is unable because of a commercial litigation issue or a commercial contractual obligation to work with the government. So actually, I think, can be used on the flip side as well to add to work with the government and protect them in a certain way. And on the question of other things in the bill that help, I think if you look at the concept of the system of national significance and the enhanced cybersecurity obligation, that provides a whole range of other mechanisms to help with companies. So, for instance, having an incident response plan may be a requirement. Undertaking cybersecurity exercises that the Secretary also covered in his opening statement, the requirement to undertake a vulnerability assessment, periodic reporting of system information, and potential installation of software to provide telemetry, I think are elements which both raise the capability of companies, particularly those assets that we are particularly sensitive, and it's a whole regime that actually, hopefully over time, will uplift capability. And so I think that the immunities sit within a broader context as well.
Okay, can we also address the question of liability questions that directly arise from ASD's actions? Because I think that was part of the Chair's question.
Sure. So in the bill, the liabilities we've put in place relate to the action directions that the technical assister would undertake with a company. And if something was to go wrong in the exercise of an action or a direction, the liability then applies. So you might think of an example about having to or work to rectify a cybersecurity incident where you reset a software system which might cause an outage. The liability from the people who are helping the asset try and respond to that incident and the asset provider themselves, that's the scenario that we've considered that the liability extends to rectifying the cybersecurity incident. And we'd say that the liabilities also act in direct proportionality to the threshold by which they have to be deployed. So there has to be a cyber security incident that's imminent, that's about to happen, or has happened. And so that's kind of hurdle number one. Then have ministerial authorisation, and then the powers are designed to rectify the security incident, the cybersecurity incident, and it's all around the rectification of the incident. It's not broad sweeping liability for any action. It is purely in relation to the high thresholds that are in the legislation, the extent of the action that's been approved at ministerial level and then administered by the Secretary, and the impact on the business. The extent to which that liability then extends right down to customers, I think, is where some individuals in their evidence before the committee have a problem with.
Okay. All right, one final question from me, and then I want to offer the call to Senator Keneally next. One of the asks of this committee is to recommend that there be some sort of appeal mechanism to contest these powers, the step-in and direction powers. Is there a way in which that could be done without harming the capability, or are these powers envisaged to be used in such extreme circumstances that litigating it at that point is going to be too costly?
Well, all administrative decisions taken under statutory schemes intrinsically, of course, are reviewable in terms of administrative decision judicial review. If the question, and I think some of the submitters, Mr Hansford, have either called for such a mechanism or in some cases even, I think, postulated as an appeal process, we would contend that the way in which the obligations are laid down by the Minister at the authorisation level and then through rules that flow from those authorisations that the Secretary then imposes, they have to be proportionate and tied back to the nexus that's set out in the legislation. Now, you can always litigate because it's available in our legal system to seek both administrative relief at merits and then also judicial review. But let's think that through. In the case of a massive, we've focused thus far on incidents. Pipelines being frozen, meatworks are being stalled, and food processing's been stalled. I think there'd be probably little prospect that theoretically would be that the Director General or I are called into a case into the federal court. From what I've read of the submissions, the concern more is for the proactive measures where there's no incident. It goes to the aviation safety sort of model. You're trying to lift the safety regime, so you've got to have a risk plan, you've got to have an incident response plan, you've got to submit that plan annually to myself as the Secretary so that I can have it checked by the DG. Mr Hansford, if you just assist me here, it would be open to anyone to go to either the AAT or the federal court in those instances. But
my understanding, Mr Pizzolo, is that the anxiety is more around these kind of emergency scenarios.
Yes.
That, as has been articulated to me by some companies, that ASD is going to come in, trample around their sensitive systems in a way that they don't agree with, and they've got no ability to say, no, don't do that, please do it this way. There's no ability to negotiate it or...
To which we would say, and we'll look at the detailed proposals and come back to you through that supplementary mechanism that you suggested at the start. We would say, and the Director General can speak to the calibre of her staff. Yes, you might know your system better, but the fire brigade know the attacker better. The conceit and the hubris that you sometimes get in these discussions, and I've seen them because Ms Noble's also enlisted the assistance of cabinet ministers and secretaries and all sorts of folks. And typically the CEO or the board member says, I've spoken to my CIO, it's all in hand. Well, yes, they understand their architecture. They often know through mergers and acquisition that they actually don't know where their data's stored. They don't know where their cloud provider is. ASD is there with the fire truck, ready to start pumping the water, and they say, we know who's causing it, we can break the attack. Do you really not want us to help? So in emergency situations, it's theoretically possible, I suppose, we'd find ourselves in the federal court, but that company's reputation, I would suggest to you, after we've taken a decision to intervene, which is in a way that's proportionate to the threat, I think their reputation would be trashed through the legal proceeding, because we would have to lay in evidence, because of the nature of the plaintiff's case, just how poor their cyber defence was, the lack of awareness they had of the nature of the attacker, where the attacker was, and their shareholders would be confronted with a situation where they say, but you had the world's best fire brigade and you didn't ask them to put out the fire.
What I'm getting at, though, is I'm more concerned about the time lost and the damage done in the meantime if these issues are being litigated.
In an emergency situation, is there anything particular to the statute, just remind me, Mr Hansford, that has that specifies the type of judicial review, or is it just simply general judicial review?
General, we've carved out ADJR review within the government assistance measures, but we have included consultation at every stage, short of a peak emergency where the government can utilise some national security intelligence to then step in and rectify an issue. There is consultation built in. There's information gathering powers, but prior to an action direction, there's consultation requirements. Prior to the top level intervention power, there's consultation at every stage, short of a peak emergency. Okay. Equally, in the design of the first part of the legislation that I note that you weren't so concerned about, there's 28 days of consultation for all of the rules, and that's to be available.
Outside of an emergency?
Yeah, so the first bit
exactly.
is...
So assuming outside of an emergency through the consultative process, if you get to the end of the 28 days and there's still a difference of view, I suppose theoretically even there you've got merits and judicial review, but if the point of your question relates to a crisis, well, we'd have to say see you in court, but the law requires the Minister for Home Affairs to make a decision, in effect tasking ASD with the agreement of the Defence Minister and the Prime Minister. We would not put them in a position where we'd say, we're not really sure about this, we don't really know, we don't really think that this dramatic intervention is required. We would almost certainly have the threat information, the intelligence on the attacker, the gravity of the attack and what they're likely to do in follow-on. You saw the pipeline, you saw the meatworks. If a company really wants to have that in court, I would regrettably have to say, well, of course they've got a right to, but it would be foolish in the extreme.
Okay. Ms Noel, anything you want to add on that?
I do just, I guess, want to add the pragmatic reality of what actually happens when we go in to help a company, and my colleagues might want to add to this story. But the reality of it is that we'll bring our weapons to bear, our intelligence, our deep knowledge of what these actors look like, our ability to reverse engineer malware, our ability to reach back to Five Eyes partners. But we can't go in there alone and not operate in a collaborative way with a network owner anyway, because the things that we need them to tell us is, where is your network? How do you pull the logs off? Who's your incident responder? Oh, they're in India, which is not an unusual, or very far overseas. Okay, we can't get them here. Where's your incident response plan? What have you normally done? I mean, the reality of this, and when we're working well with a company, and we're working well in the spirit of our national interest, because we're talking about organisations here whose services or capabilities are providing a service to the nation, that are part of our critical infrastructure, not sort of any small company. The reality is that on the day we will have to do this in partnership together, and we will listen and hear their expertise about their network, and what we hope in exchange is that they will listen and hear and act on our expertise about how to fight criminals and state actors who have malign intent. That's the reality of what it looks like on the ground, and to the extent that those national interests then intersect with their own commercial interests, because their imperative is to get their network back up for their customers, the service, the people they employ, then sort of that's the reality of how these things work now, and it happens now. We do this with companies when they let us in voluntarily and want to act in those joint and shared interests for the nation. What this legislation does is provide safety nets, imperatives and expectations for those corporations who don't choose to act like that, and time is the imperative here. In a scenario where we're in a court and the power's out in New South Wales.
Yep. Good luck with that. Mr Chair, I know you want to move to Senator Keneally.
Yes.
Just one very brief comment. The virtuous cycle, though, of doing the proactive work outside of a crisis, so the lodgement of incident response plans, the lodgement of a cyber risk plan, the ability, the flow of information that will come in to the Home Affairs Department, to our regulatory area, which we of course would then share with ASD. Some of those questions, ASD over time, I anticipate, Ms Noble, would build a catalogue of war plans, for want of a better word, or game plans to say, right, this sector is configured like this, whereas that sector uses cloud or similar. So their emergency response is actually enriched and improved by working collaboratively outside of a crisis. So the proactive, if you will, peacetime operation of this statute helps in the crisis times as well.
Okay. All right. Thank you very much. I've taken